This is Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our web address is libertylawsite.org, where you can subscribe, comment, find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org. Today we are discussing with historian Gordon Wood two new volumes that he has edited for Library of America entitled The American Revolution, Writings from the Pamphlet Debate. Professor Wood hardly needs an introduction. He is the Alva O. Way Professor of History Emeritus at Brown University. His books include the Pulitzer Prize-winning The Radicalism of the American Revolution, the Bancroft Prize-winning The Creation of the American Republic, 1776 to 1787, and most recently, Empire of Liberty, A History of the Early Republic, 1789 to 1815. Professor Wood, thank you so much for joining us today.
My pleasure.
So we have two volumes, The American Revolution, Writings from the Pamphlet Debate, dating from 1764 to 1776. Kind of sketch for our readers, if you would, what is the Pamphlet Debate? What's it about?
Well, as many people might not quite realize, but this is the 250th anniversary of the Stamp Act. And because of that, the Library of America asked me to edit some pamphlets that constituted the debate that was launched really by the Stamp Act, although there is some earlier, I have one pamphlet included from 1764, that went on from 1764 to the Declaration of Independence, which ended, of course, the debate with American independence.
So the Stamp Act itself, what's that about, and why does it cause such a commotion? I mean, it's really not a tremendous tax that's imposed on the colonists, and yet it causes so much of the controversy that's debated in these volumes.
It was a tax placed on most paper products in the colonies. Now, the colonists themselves were used to stamp taxes. They used it themselves, but they had never been taxed in this way by the British Parliament. This seemed to them to be a serious violation of their rights, and they were quite concerned, or quite legitimately, I think, that this could be the beginning of an incursion into their internal affairs that they had never experienced. The colonists had been left pretty much alone for a good part of the 18th century. The empire really, the imperial force really operated on the periphery with duties regulating trade, but the colonists had never really experienced the force of imperial power before in quite this way. And the Stamp Act sparked a firestorm of opposition up and down the colonies, and except for Georgia, which issued a couple of stamps, none of the colonies issued any stamps. It was just killed at the outset.
So if we back up for a minute, I think the first document we have in here is 1765, but preceding that is a change. I mean, you mentioned the British leaving the colonies alone. We have the famous term salutary neglect, maybe, to describe that.
Right.
There's a change noted in 1763, the conclusion of the French and Indian War, and a debt incurred by the empire. As they see it on the colonists' behalf, they think it quite just to impose that debt or a payment of that debt on the colonists, which is sort of sparking these new taxes and these new regulations. So maybe talk about that for a minute, because it seems. We have two sides, I think, contending for the soul of British constitutional liberty, but preceding all of that is something that seems quite decent, or not certainly immoderate on the part of the empire to expect some sort of payment for services rendered, in effect.
Well, that's right. The 7 Years' War was concluded with the Peace of Paris in 1763, and it made Great Britain the greatest power the world had ever seen up to that point. And France was expelled from the North American continent, and the colonists had that enemy removed from their rear. And it was a costly war. The British were deeply in debt, and they expected, they needed help. They needed financial help, and they thought that the colonists were quite wealthy and quite. In fact, the returning soldiers said this is a land of milk and honey over there, and they ought to be paying their shares, especially since the war had been fought largely on their behalf. The 7 Years' War was the first war between France and Great Britain where the major theater of a war was in North America. So from all these considerations, it seemed quite logical for the British to impose a tax of some sort. So you can make a very good case that the British needed help financially, and the colonists were quite wealthy. They probably had a higher standard of living of any people in the world at that time. And I think that from the British point of view, it seemed quite logical to tax them.
The pamphlet debate itself, sketch for us, maybe what are the types of constitutional arguments the colonists are making, as opposed to the British, who also logically see the Parliament coming out of the great crisis of 1688 as a sovereign and has being fully in control throughout the empire and able to impose taxes wherever or regulations wherever they deem fit. And the colonists seem to be making, on one read, kind of a more antiquated argument, appealing to the great common lawyer Edward Coke, among others, to make this notion or make the argument that they are in fact or should in fact exist apart from regulations by Parliament because their status is under the king. But they seem to be recurring to older notions of English law that have been jettisoned. And so maybe kind of ease us into what the contest is here.
Well, it starts with the Stamp Act and essentially with the rumblings from the colonists, the British, and in this case a man named Whately, who is the sub-minister who actually wrote the act for George Granville, who is his boss in the Treasury, and he writes a defense of the Stamp Act on the ground, because the Americans immediately raised what was a common British theme: no taxation without representation. You couldn't have your property taken away without your own consent. That had gone back deep into parliamentary history, and it was a major principle of English thinking. Well, Whately raises the argument, or raises the notion that, yes, you did consent to this. You were virtually represented. They actually use that term, virtually represented. And it has to do with a very different notion of representation that the British had, that the criterion of representation was not voting, but rather the mutual interest between the constituent and the representative, so that you didn't actually have to vote for someone to be represented, because there were large numbers of Englishmen in Manchester, Birmingham, these new burgeoning industrial towns, who had no vote. They did not vote for any single representative, and at the same time there were towns like Dunwich, which had long since fallen into the North Sea and was nonetheless sending 2 representatives to the House of Commons. So representation for the English was very different from the Americans. The American sense of representation had been based on actual experience, and they use the term, we believe in actual representation. Every time a new town was created in Massachusetts, they sent 2 members to the General Court. And the same was true in Virginia. When you had a new county created, they sent 2 representatives to the House of Burgesses. So the Americans had a very different experience, and it was within memory in many cases that their representation had been created, where the English went back to the mists of time, back to the 13th century, and the whole notion of representation was very different. They had no similar experience as the Americans did. So these 2 contrasting notions of representation, the American based on actual representation, where the criterion of representation was voting. You actually had to vote for someone to be represented, was in conflict with this virtual representation where voting was incidental. And what really counted, did the representative represent your interests in some general sense? And those 2 contrasting ideas of representation is fantastic debate on those 2 on that issue, and that really launches the debate.
On this question of representation, there's also the appeal to the colonial charters themselves, that the colonies actually see their origin, their creation, coming from the king and not from Parliament, and this establishing a clear line of authority and a belief that they, in certain respects, they are pro-monarchical because they want to be under the royal prerogative and not under Parliament.
I think that comes a little later. That
Okay.
comes a little later in the debate. The debate evolves. It doesn't. The major issue doesn't immediately exposed. The next step is really moving from representation to the issue of sovereignty, and that comes in essentially in the end of the decade in 1769, because the British finally say, look, if you're going to expect, see, the Americans' response was, look, we're willing to accept parliamentary regulation of our trade. We've done that since the 17th century, the Navigation Acts and so on, but we will not accept taxation. And that distinction the colonists try to cling to because it's part of their experience. They have been accepting the regulation of their trade by Parliament. Well, what the British respond with this doctrine of sovereignty, which was something that emerged in the decades following the Glorious Revolution of 1688. And what it held was that there must be, in every state, one final, indivisible, authoritative lawmaking power. And that power was in Parliament. And it can't be divided. It's indivisible. So what William Knox, who was another one of these sub-ministers who was commissioned to write a pamphlet, says in 1769, if you accept one iota of Parliament's authority, that is to regulate your trade, you have to accept all of it. You can't divide it. And if you deny Parliament's authority in any one respect, you have to deny all. And that becomes the issue. It busts the whole debate wide open. And the colonists, with that kind of alternative, are forced to cut their ties to Parliament completely. Very interesting exchange. Thomas Hutchinson, who was the last civilian governor of Massachusetts, decides in his naivete to raise this issue in 1763 in a series of lectures he gives to the General Court, that is the legislature of Massachusetts. He raises this issue. You've got to accept Parliament totally or not at all. And the reason that good Whigs like Lord North or Thomas Hutchinson, they aren't Tories, believe that, of course, when confronted with that choice, no good Englishman in his right mind would not want to be under Parliament, because Parliament, we forget this, Americans forget this, Parliament was the bastion of liberty. Parliament created the Bill of Rights. Parliament created the Habeas Corpus Act. Parliament is the source of English liberty. It's the protector of English liberty. So if you're outside of Parliament, you're susceptible to the power of the Crown, which is, in a good Whig, is always dangerous. You don't want to be susceptible to the power of the Crown. You want Parliament to protect you. So when Knox and then Hutchinson give these alternatives, they assume that, well, of course, anybody in his right mind will want to be protected by Parliament. But the Americans, who have not had this experience with Parliament, when confronted with that choice, they say, all right, if that's the case, and this happens with Samuel Adams and John Adams when they're confronted with Hutchinson's alternative, they say, if that's our choice, that we either have to be totally independent of Parliament or totally under Parliament's authority, we're going to choose independence. And from that moment on, from 69, 70, 71, you have all of the major intellectuals, whether it's James Wilson or Thomas Jefferson or John Adams, they all conclude that the colonists are no longer under Parliament's authority. We're tied only to the king. Now, historians have called this the Commonwealth theory of the empire because it's an anticipation of the Act of Westminster of 1931 that created the modern Commonwealth. As you know, Australia and New Zealand and Canada have a common sovereign, Queen Elizabeth, but they have independent parliaments, independent legislatures. That was what the colonists began arguing for by 1770 and 73. By 1774, everybody is saying that. Now, the consequence of that is that when the Declaration of Independence is declared, there's no mention of Parliament. These guys are all lawyers. They're very scrupulous about this. And you read through the Declaration, it says, you, George III, have done this, and they accuse George III. But George III was just one factor in this. It was Parliament that passed the Stamp Act. Parliament passed the Coercive Acts. Parliament passed the Townshend Duties. But Parliament's not mentioned because they had already concluded legally, constitutionally, that they were not under Parliament's authority. Therefore, they had, in order to break from Great Britain, they didn't have to discuss Parliament at all. Closest you get is when I think they mention, you, George III, have conspired with others being Parliament. So it's an extraordinary, very legalistic constitutional debate that goes on through this decade.
On this question of sovereignty that Parliament claims, and so we have the repeal of the Stamp Act simultaneous with that, the passage of the Declaratory Act asserting that they have the full right and authority to regulate the colonies. Is there not the notion that the claimed sovereignty of Parliament over the colonies is in some respects, in the colonist view, a reincarnation in Parliament of a Stuart Crown view of power? That is to say, law is force. Law is what we say it is. It's no longer this idea of some sort of power assigned for a specific reason or a specific purpose. And that itself must be reasonable and must have precedent, et cetera, tied to it. That Parliament, in claiming this authority, has now become unlawful under the British Constitution.
Well, James Otis argues this very early. He has a very, how should we put it, a Cookean notion of law, that law has to be right to be law, and he has a kind of, I guess you'd say, a rudimentary notion of judicial review. He doesn't see law as simply the command of a sovereign, which is what most people by the middle of the 18th century believe. It's no longer, as Coke saw it, law had to be just and be in accord with the common law rules to be law. Coke, in Dr. Bonham's case, simply set aside an act of Parliament on the grounds that if Parliament were aware of Parliament being a court itself, would not want this to take place because a man would be a judge in his own cause. So Coke is thinking in what you might call medieval terms about law. Law is not the command of the sovereign. By the middle of the 18th century, there are very few people left in the Anglo-American world thinking like that. Now, Otis happens to be one of them. And he as a consequence, his pamphlets, and he writes several of them, are received with a good deal of confusion, because on one hand he'd say, well, Parliament is supreme, it's authoritative, but at the same time he says, well, it can't pass the Stamp Act. Well, if it's supreme, then how come it can't pass the Stamp Act? Well, he's arguing that the Stamp Act is inherently unjust, and it's a violation of the common law, and Parliament can't do anything that's in a violation of the common law. So he's thinking in what you might call old-fashioned terms. But most Americans come to realize that that's no longer applicable, that kind of thinking, and they already are familiar with the notion of law as command. That is, whatever the legislature says, that's the law. Now, obviously, Americans have a very different view of that. It developed later under the development of judicial review, but they don't really repudiate. They aren't really accepting Otis's view, because the way judicial review eventually develops is we have a constitution, which is a more fundamental law than the statute law, and so we're still operating, so to speak, under the notion of law as command. Anyway, that's a complicated situation, but by most Americans have adopted and accept. That's what I guess is ironic. We accept the notion of sovereignty. They finally give up on it. They simply surrender to it. They can't. They try to argue, look, no, Parliament can do this, it can regulate our trade, but they can't do that. And they try to divide up Parliament's authority, and the British keep coming back. You can't do that. It's indivisible. So finally, the colonists say, all right, if it's indivisible, that's it. We're going to be independent of Parliament. So in that sense, they're surrendering to the doctrine of sovereignty. They can't divide it.
I mean, so help me understand, though. You say most Americans accept the idea of law as command and law as force. I mean, help me understand, because as I read through these documents and these volumes, it seems to me they actually are that would give up the pamphlet debate in a sense. I mean, they are saying that law is it must be limited, it must be reasonable, and over again I see this appeal to natural rights in these documents. It would seem to me it's not necessarily a modern notion of law as command that they're accepting. That's what they're disputing. So help me understand that.
They're appealing to natural rights because, or actually rights of Englishmen. The natural rights comes late. They're appealing to rights of Englishmen that cannot be violated. But in England, you see, the rights of Englishmen are not rights against Parliament. Parliament is the people. And the rights of Englishmen have always been considered. This is the context for the English position, which is very confusing to the Americans. The context for the English position that their rights are rights against the Crown. The Crown is the source of tyranny. The Crown is the source of oppression. Parliament steps up and acts as a barrier against the Crown. That's what the Bill of Rights was about. The Parliament passes the Bill of Rights. The Parliament enacts the Habeas Corpus Act. And of course, even today, Parliament is still sovereign. It can do away with habeas corpus, which it did in Northern Ireland. There's no constitution to protect the rights of Englishmen against Parliament. This is the context for the Americans. When they talk about rights, they're talking about rights as Englishmen understood them, the rights against Crown power. And the English can't understand the Americans when they say, well, you don't have any rights against Parliament, because Parliament is the bastion of your rights. It's the bulwark of your rights. So there's where the confusion comes. The Americans are groping to understand this, and they begin suggesting, well, maybe we need some kind of constitution, a kind of more fundamental law to protect us against Parliament. And so you have the beginnings of that kind of thinking, which doesn't get really expressed until 1776, when the colonists have to, create their own constitutions. Then the distinction between fundamental law and statute law begins to emerge. But through this whole period, there's a good deal of confusion, because rights, as far as Englishmen are concerned, are rights protecting them, which are designed to protect themselves against the power of the Crown. The English have no rights against the power of Parliament.
But I suppose that's what's at issue, though, is the colonists are saying sovereignty of the Parliament cannot be understood to be violative of natural rights, or to be employed in a way that violates.
That's correct. They're beginning to treat the Parliament as if it were the Crown, which is very confusing to Englishmen. You see, if you could see that distinction, as soon as you begin to treat Parliament as a kind of crown, as like a traditional source of tyranny, it's very confusing to Englishmen, and it's difficult for the Americans too, because they're the only thing that first they can argue is that, look, we're not represented there. Mm-hmm. And if they were represented there, presumably they'd have to obey everything Parliament did. But that's why the representation is so crucial. They're not represented.
Well, there's a fundamental rejection, it seems, of the very idea that Parliament could be sovereign. That is, sovereignty itself is a metaphysical, abstract notion that shouldn't be applied to government.
They buy into it, because that's why they have to disavow all Parliament's authority. That's what happens. Every single one of them. By 1774, Franklin, James Wilson, John Adams, Alexander Hamilton, anyone who wrote a pamphlet by 74 is repudiating Parliament's authority over them, just saying we're not under Parliament at all. Mm-hmm. They all reached that conclusion. So in that sense, they've surrendered to the idea of sovereignty. They simply say we're tied only to the Crown, and that's the position reached, I think, almost universally by the the Whigs, the Patriots, by 1774. So that the cut comes only with the crown at the end. So 2 years later, they only have to cut their tie to the crown. I think it's a surrender to they don't really, they're not able to handle it. It's too imposing, it's too powerful, that doctrine of sovereignty. And of course it comes to plague them later in the debate with the Anti-Federalists, Federalists and Anti-Federalists. The same issue is raised over sovereignty, because the Anti-Federalists will say, well, look, what's going to happen with this supremacy clause, and there has to be one final, supreme, indivisible lawmaking authority. It's bound to be the federal government. The states are going to be reduced to, laying out roads and measuring the height of fence posts. They're going to lose all power. And the Federalists keep saying, no, we're going to divide power. We're going to divide the power. The federal government will have some, and the states will have others. And the Anti-Federalists keep throwing back this doctrine of sovereignty in their faces, the same way that that William Knox and Thomas Hutchinson had in the 60s and 70s. So, and finally, of course, the answer that's reached is James Wilson, a brilliant. He says, look, we're not going to divide sovereignty. It can't be divided. We're going to relocate it. We're going to put it in the people. The lawmaking, the final, indivisible, supreme indivisible lawmaking authority will be in the people. And it suddenly, when Madison reads the speech that Wilson gave, he says, all our problems are solved. This is how we're going to do it. So that the people remain sovereign, and they dole out pieces of their power to various agents. It's a brilliant intellectual solution to this problem of sovereignty. So it doesn't go away. And then, of course, it remains a major problem right up through to the Civil War.
I wanted to just briefly mention this document, which I had never encountered, and I thought it was fascinating. And it was by an English author writing under the name Cato. 1765 is the date.
Right.
It's an amazing document in my mind. One, he says to his fellow British subjects, look, we keep forcing these guys to do business with us. We keep forcing them to take our wares. We force them to sell to us. And it could very well be the case that they're going to be more powerful than us. The country is vast. There's extensive territory and resources. And you're actually turning them against us with these policies. You're short-term success, short-term gains in effect. But you're ruining sort of the bonds of concord and amity here with all of these sorts of regulations, command control regulations, we would say. And then he makes this appeal to free markets, that free markets would be the better way to go and would result in us, the British, producing better goods and providing them throughout the empire. But also we would have better trade for all sorts of reasons, comparative advantage. Talk about that document, if you will, because it's the first document in the collection.
Right.
But it really does. I mean, it's a brilliant way setting the stage for the debates that will follow.
Now, we don't know who wrote it, but and I've consulted with everybody who would know anything about it. No one seems to know who wrote that. But, of course, there were other people saying similar things, that the empire needed to free up its trade. And, of course, Adam Smith climaxes this when the same year the Declaration of Independence is with Wealth of Nations, 1776. So there are people thinking like this, and of course there were many of the colonists thought that they were going to eventually be bigger than the mother country, but the future, of course, is a long way off. But there were people who, because the population was growing faster in the colonists than any place else in the Western world. It was doubling every 20 years. There was nothing like that in England or on the continent. So there was this sense. Franklin had already anticipated this in 1750 in an essay. If you're going to double every 20 years, you're going to be big pretty quickly. And so I think there were lots of people who anticipated the growth of this population. It was about 2.5 million in 1776 or so, versus about 8, 9, 10 million maybe in England. But if you're growing faster than the mother country, you're going to soon surpass it. And of course, it probably occurred somewhere in the middle of the 19th century when we became larger than England. But But that was always I think many of the colonists anticipated this. But of course, that seems a long way off. Just as for us, when we talk about the demographic changes taking place in the United States today, it seems, well, when is that going to happen? Maybe 30 years from now, 40 years from now. It seems like a long way off, and you don't think in terms of your present problems, in terms of what will happen 30 years from now.
But also, the Cato document, as you think through it, you see all sorts of ideas. Two contrasting notions. The British Empire seeming to, being on a warfare footing, on a debt footing, trying to think of ways it can use trade, it can use the colonies to support itself. The
right.
center, and power, ambitions, etc. It's keeping the empire strong, and not so much thinking about what the colonists seem to be pointing to, which is this frequent appeal to political liberty, to constitutional liberty, and just sort of having that freedom of life. I don't know how else to say it, that they've experienced under the self-government traditions that we've discussed. So it seems to me already in the Cato thing we're opening up to, there's just two contrasting notions of what government is for that's being expressed.
Definitely. There's no doubt that's true. And the colonists are, when they come to confront the British, they're trying to interpret their own experience. And what's really ironic about the whole debate is that the colonists see themselves as defending the English Constitution.
Yes. Yeah.
It's only late that they turn to natural rights, because there's a debate in the Continental Congress where they say, 74, 75, they say, look, it's getting embarrassing. We keep talking about English rights, and yet we seem to be on the verge of breaking from England. Maybe we should call these natural rights. They aren't just confined to Englishmen. And so they actually have a discussion of that sort, that they suddenly feel that if we keep appealing to the rights of Englishmen, that's too limited. But it's really quite extraordinary that the whole debate is conducted with the Americans seeing themselves as the true defenders of the English Constitution. They are the ones appealing to the rights of Englishmen that are being violated by the English themselves. So it's a very unusual revolution, if you will, in constitutional terms, that they should see themselves as that they revolted not against the English Constitution, but on behalf of it.
Yeah.
I think James Wilson actually makes that point. He said, we're revolting on behalf. We're conducting a rebellion on behalf of the English Constitution.
Yeah, James Otis, which is one of the early documents in the collection, 1764, The Rights of the British Colonies Asserted and Proved. He seems to appeal not to natural rights, but to a law of nature as being sort of the ground of political freedom that is being potentially denied the colonies, or that will be denied the colonists if they don't, stand up and make a manly defense, I think is a phrase he uses, against these intrusions by Parliament. So there seems to be already an attempt to get to the ground of individual freedom, or not individual freedom, but political liberty in this sense early on.
Right. No, I think that's true. But many Englishmen thought that their rights were identical to natural rights. They may have been. They realized that other countries, France, for example, did not have these rights, but nonetheless, they did believe that they existed in nature, so to speak. And so there is a constant interplay between rights of Englishmen and rights of nature, or natural rights. I wouldn't. They aren't philosophers, these people, so they're not making the kinds of distinctions that a modern philosopher might make, but they certainly did use these terms sometimes interchangeably. But certainly after 74, 75, they shift to almost exclusively talking about natural rights, even though they are still talking about the common rights of Englishmen. They can't trial by jury and can't be taxed without representation and so on. All of these rights that they talk about are the rights that are traditionally part of the English Constitution.
What do these documents reveal to us about the formation of the American mind at this point? Can we say that there's an American mind on constitutional liberty, rights, government power, coercion in these documents, or are these guys, as soon as the colonists writing about Parliament, are they actually disagreeing with one another on these crucial questions?
Some of these arguments are with one another. Daniel Delaney, who writes against the Stamp Act eventually becomes a Tory, and of course Hutchinson is definitely an American-bred governor, and he becomes a Tory, or a loyalist, I should say. And Thomas Paine is the guy who writes the most fiery pamphlet, is a recent immigrant from England. So it's a complicated business to talk about America and England. I mean, there is a transatlantic world, but the radical Whig position, which is being, which in England, of course, there are radicals who agree with the Americans, who are critical of Parliament, who are critical of the representational system, the absurdity of it, or at least by our standards, it seems absurd that towns that no longer exist can send representatives to the House of Commons, and Manchester and Birmingham, which have 50,000 people each, have no representation. I mean, that seems absurd to us, but to the English it made sense. It made sense to Burke. It made sense to very smart people, and actually the notion of virtual representation has something to say for it. It's the only justification for majority rule, because if voting is the criterion of representation, and your candidate that you voted for loses, does that mean that you're not represented in the legislature? Well, if you follow out the logic of actual representation, that's what happens. And yet we don't go that far. So the virtual representation actually is the best answer to majority rule that's ever been posed. So the actual representation has, philosophically has a lot of problems with it, because if the criterion of representation is that you actually had to vote for the person, and that person doesn't get into the legislature, then in some fundamental sense you're not represented.
It seems to me something we've been discussing too. I've always thought that's kind of it's not a pure smoke screen, but it seems to me what they're most concerned about is preserving the authority of their own assemblies within the colonies.
Of course. I mean, there may be all kinds of selfish motives, but they do conduct the
well, I don't think it's a selfish motive, but
well, there might be selfish motives involved. They're concerned for losing their property and so on, but
they thought that was the locus of their political liberty, was in those assemblies. So the virtual representation, I mean, they disagreed with that, but that's what they wanted to preserve, was the integrity of those.
They just didn't trust having. None of them really. Franklin throws out the notion of maybe you can have a Scottish solution. You'll give you 100 representatives and send you to London, and no American that I know of, no Whig accepts that notion of actually sending representatives to the House of Commons. Not that the House of Commons would have accepted it, because it would to do that would have not only enlarged the House beyond its already enlarged size. The House of Commons in the 18th century was larger than our present House of Representatives. It's about 560 members or something like that. So, but there was never any serious consideration to sending representatives. Our representatives had to be local. They had to have residency requirements. We had all kinds of traditions that the English simply hadn't experienced at all since the 13th century. So, we were defending our sense of representation as it had developed in the 150 years, 60 years of our history. So you're quite right about that.
So we're a medieval holding ground for political liberty.
Well, there's no doubt that they were concerned about liberty, and that is the word used over and over again, along with slavery, which is interesting because they keep saying that this will enslave us. The British will enslave us. And of course the irony is, except for a few like Otis, they don't see any contradiction between the holding of slaves and their use of the image of slavery that the British are imposing on them. That's what Dr. Johnson comes in with that famous phrase. How is it that we hear the loudest yelps for liberty from the drivers of Negroes? And of course that's a wonderful satirical point, and it's being used now by many historians who have turned the revolution into a defense of slavery.
Well, that they're also laying down the principles that can be used. Of
course, and that's right, and of course that's exactly what Otis says. and others too. They see immediately that there is, many of them, especially in the North, see a problem when you're invoking liberty. How can you be holding slaves? And of course that's exactly what happens.
Yeah, I mean,
the revolution really changes the debate over slavery and creates slavery is a problem. It had never been a problem before until the American Revolution. You know, the first anti-slave convention held in the history of the world is held in Philadelphia in 1775.
Yes.
I mean, that's not coincidental. Yeah. Those two things should come together in Philadelphia.
Well, of course, we I mean, this is all. The idea of a mass-based anti-slavery movement is something that emerges, early 19th century. I mean, it's in itself unanticipated, I think, by anyone at this time. I mean, the principles are there. There's the anti-slavery convention, you note, but that in itself is the new event that we have to account for.
Right. No, but the revolution and its debate over invoking liberty really make suddenly you see the anomaly.
I want to talk about the Coercive Acts, which seems to really, that fast forwards everything. We get into the second period, really. Coercive Acts, you briefly know what that is, but think about Thomas Jefferson, Some Review of the Rights of British North America. Also, we get James Wilson's powerful essay, and then Samuel Johnson, you've noted him. And then also Edmund Burke, which, this part of Edmund Burke's career, frequently not discussed, it seems, by a lot of people, or not known in terms of, if, not a radical Whig, but someone who presses a case on behalf of the colonies, even while he's preserving intact the view of parliamentary sovereignty, but is prudential, trying to find a middle way, perhaps we would say, of letting the colonies have their essential liberties as they understand them. And sort of stepping back and letting the pressure off.
Right,
so all of that sort of rounds out, in large measure, the pamphlet debate. Maybe we can kind of touch on each of those points.
Well, I think Burke is an interesting figure because he is seen as a hero by many Americans, but he really doesn't intellectually support the American cause because he's a strong supporter of Parliament and parliamentary sovereignty. His party, the Rockingham Whigs, is the party that passed the Declaratory Act. So, but he is pragmatic, and he certainly is sympathetic to the colonists. He does not want to raise the colonists' hackles. Let sleeping dogs lie is his argument. Just these arguments that you're raising belong in the schools, in the universities. Let the professors argue about these things. But we're politicians. We don't do things like this. We're just creating problems for ourselves. That's essentially Burke's message. But and when, of course, when the revolution breaks, he and the Rockingham Whigs are forced into supporting the revolution because any conciliation would have to be based on an enhancement of the crown, that the colonists would be tied only to the crown, and that's impossible for Rockingham Whigs to accept that. See, they fear the crown. They are old-fashioned Whigs who feel that the source of tyranny is in the crown. And so when the break comes and the British are making all kinds of appeals to the colonists, come on back. The only way they'll come back is tied to the crown, and the Rockingham Whigs are forced to support independence because the alternative is disastrous for them. It's an interesting development because the Whigs, the Rockingham Whigs, are the great supporters of parliamentary sovereignty, which of course is the source of the ultimate thing that broke the revolution or broke the empire. By the Coercive Acts, I mean, the crucial event, I think, is the Tea Party in December of '73. Things were really sort of not happening, and radicals like Samuel Adams wanted to kind of, North was trying to calm the waters. He'd repealed. See, the British keep repealing everything. There are some scholars have called this appeasement. They're appeasing. The protests against the Stamp Act, and they repeal it. Well, for Parliament to repeal, go back on what it did just a year later, is kind of embarrassing. This is the great Parliament doing this. And so then the Townsend duties, well, there's protests against the Townsend duties, non-importation, and they repeal them all. They keep one insignificant tax on tea. And so when you get to the Tea Party, which is engineered by radicals who are looking to create a situation, North had made a mistake in not, he didn't think that his Tea Act was going to cause any problems, because the colonists would be able, he was giving a monopoly position to the East India Company that would allow tea to be sold, or British tea to be sold cheaper in the colonies than any Dutch smuggled tea. So he thought the colonists would be happy to have cheap tea.
Yeah.
But of course, Samuel Adams uses this as a pretext for the Tea Party, where they destroy 10,000 pounds of tea, throw it in the harbor. That's a lot of money. That's millions of dollars today. And that creates an outrage. At this point, the Parliament says, look, we've been teasing these guys all along. Enough is enough. We're coming in strong now. And that's what they do. And they see Massachusetts as the source of all this trouble. They don't realize that the other colonists are supportive. And actually, the other colonists are not supportive of the Tea Act. The Virginians, and Virginia is by far the largest colony. Without Virginia, you don't have a revolution. I mean, it's the richest, it's the most populous, it controls most territory. It is by far the key colony, not Massachusetts. So the Virginians are really upset by the Tea Party. They think this is destruction of British property. I mean, this is a violation of British rights and so on. And they're very upset by this. And the British, however, instead of appeasing once more, they come in with the Coercive Acts, which repeal close the port of Boston, violate the Massachusetts Charter, do away with town meetings except once a year, and appoint a governor, a military man, a general, as the governor of the colony. Well, these Coercive Acts change everybody's mind. If the Virginians say, look, if they can do that to Massachusetts, they can do that to us. From that moment on, the revolution, it seems to me, is inevitable. Because once Virginia's on board with Massachusetts, there's no stopping. The British really create that problem with the Coercive Acts, but you can't blame them. They've been appeasing up to this point. The Coercive Acts are passed by overwhelming majorities in the House of Commons. So at that point, there's no more possibility of conciliation.
The principle, I mean, it's interesting, we talk about they're appeasing the colonies. I suppose in the mind of Samuel Adams and others who brew the harbor, there's still the principle at stake. You've repealed everything except for the tea tax. If I accept that, then haven't I not accepted the principle that you can regulate the colonies?
Oh, no, that's right. They were able to exploit that, definitely. There's no doubt of that. But I have no doubt that Adams is trying to provoke. He wants a revolution. Yeah. I think it's hard to know. They can't say this publicly because that would be treasonous. But I think Adams is probably from 68 on at least is thinking of but nobody says they want to revolution. The Continental Congress keeps talking about conciliation almost right up to the end. They're sending over all kinds of peace feelers and so on. But at that point, it's almost impossible to see how the accommodation could be worked out.
It seems also, when you think about the American mind, were the tea the tea products under this tax, were they accepted throughout the colonies, or was there sort of a kind of an unspoken agreement? You can't take these and bring them into the into the towns and cities.
You mean the Tea Act, or the
the tea that came in under the Tea Act? Was it rejected universally throughout the colonies?
Pretty much so. Yeah,
that's interesting.
Right. They just simply, the ships go back. In most cases, they just aren't allowed to unload the goods. In the case of Massachusetts, Hutchinson is such a stickler for things. He wants the goods unloaded, and therefore the duty would be paid. If you don't unload the goods, then you don't have to face the issue. You can just send the ships back to England. We're not going to take this tea. But Hutchinson actually wants a confrontation. He doesn't realize what's going to happen. So he says, we're going to unload this tea. And at that point, the colonists come in, and they're not going to pay the duty, and they destroy the tea. So, again, they're trying to, it's a lot of, what's fascinating about it is this constitutional scruples they all have. And I think that goes to the Declaration. The fact that they don't mention Parliament at all in that document is fascinating since Parliament had been the source of all of the oppression. So, but they had, at this point, they were no longer constitutionally connected to Parliament in their own minds. And that therefore they had to take account of that. I find this kind of nicety of legalistic niceties is fascinating.
We began this discussion with the king. Maybe we can end with the dismissal of the king. Thomas Paine's Common Sense is the last document in this collection. You note in your brief introduction that one of the principal matters that Thomas Paine discusses is that we can finally dismiss the king as a source of authority. It's okay for the colonists to sever themselves from him, and that this has some sort of tremendous impact in their own thinking, or guides thinking that was there, something along those lines. Maybe we can talk about the reception of Thomas Paine's Common Sense here at the end.
Well, it actually isn't the last, because there is a response to Paine that I've included, and then also Thomas Hutchinson's response to
sorry.
But Paine is the crucial pamphlet, and it's written in a very different style. As you compare it to, he has kind of barnyard imagery. He does not need his readers to know anything but the English Common Prayer Book and the Bible. He doesn't invoke Cicero. He doesn't invoke Pufendorf. He doesn't invoke when you compare his pamphlet with Dickinson's pamphlet, which is loaded with footnotes, citing all kinds of sources in Western culture. Paine is direct. He's aiming his pamphlet at a middling sort, a tavern going kind of population, and it's a fantastic. It's full of rage and passion. He's not trying to explain. He's not trying to persuade. He's just venting feelings, and it's extraordinary. People are really stunned by it, and they keep talking about it because it violates all the rules of rhetoric, and he changes the English language in some fundamental way. That is, pamphleteering up to this point was an elite endeavor. These people are all the people who wrote Jefferson and Wilson. These are all educated people, and they write for each other, essentially, with all kinds of citations to Western culture. Whereas Paine is simply venting feelings and passions, and it's a very different world that he's setting forth. And I think that's what's so radical about his pamphlet.
Gordon Wood, thank you so much for your time today. Very much appreciate it. We've been talking with historian and Professor Gordon Wood, 2 volumes. He's recently edited The American Revolution, Writings from the Pamphlet Debate, just published by Library of America. Thank you so much.
My pleasure.
This is your host, Richard Greinch, and you have been listening to a podcast that can be found at libertylawsite.org, where you can subscribe, comment, and find other episodes and links related to today's conversation. Our email address is lal@libertyfund.org.